Docket number SJC-13444, Commonwealth versus Emilio Delarosa.
Okay, Attorney Mencken.
Good morning, Attorney Michelle Mencken on behalf of Emilio Delarosa. May it please the court. Our position in this appeal is that the trial judge's initial denial of the defense request for a manslaughter instruction at the close of the Commonwealth's case was reversible error, even though the instruction was ultimately given, because the effect of that initial ruling was to force the defendant to testify where he otherwise wouldn't have, and that testimony ended up harming his defense more than helping. So on the basis of that prejudice, he ought to be granted an opportunity to have a jury fairly consider the evidence that was in the case of reasonable provocation, the evidence that came in through the Commonwealth's case.
How do you address the delay between the receipt of the information and the homicidal act?
Well,
as far as heat of passion goes, of course.
Sure. So, of course,
Can you just outline for me how long was it?
Well, in the Commonwealth's evidence, that really wasn't clear. We really didn't have a sense. We just know it was sometime prior. After Mr. Delarosa testified, I think the
relevant inquiry right now, because of the claim of error, is what evidence was before Judge Tabit at the time of the request, right?
At the time of the request, the time frame was not clear. It just said that he had found the letter while doing laundry, and at some point thereafter, Wanda came home and they sort of closed down their activities and went to bed. The time frame is not established in the Commonwealth's evidence.
Although doesn't she come home around 9 and then it's after midnight that the killing occurs?
Well, your recollection may be better than mine, but my notes and recollection are that it was very ambiguous what time she came home until Delarosa testified. I'll be happy to look and make sure that I'm correct.
We know two things occurred, right? We know they have a pleasant conversation because he doesn't want to bring this up because they're having a nice conversation. Then they go to sleep. So then she wakes him up and then we start, right?
That's right. So to answer Justice Gaziano's question, the way that I address this cool down period, because you're not supposed to have a chance to cool off, is that really the provocation is not the discovery of the letter itself, but it's the confrontation about the letter. It's what happens during that final fight that that's the juncture that we need to look at. I maintain that the character of the letter that he had found is an important backdrop, and it helps explain how he would have been feeling at that moment. But we have evidence from Mr. Delarosa's statement to police that he said to her, "Hey, what's this? Were you really confused about?"
Doesn't that take you out of shops? If it's just if it's a regular confrontation, now we get just to arguments. Because to get the instruction, there has to be a revelation, regardless of the relationship, but there has to be a revelation of infidelity, right? Now you're telling us that it's not the revelation of infidelity in the letter, it's the argument they have, right? So we have this very narrow, which doesn't exist anymore. We have a very narrow theory here, and you're past that because now we have an argument, which is just mere words.
The reason I think we're still in the ballpark of schnapps is that, as in schnapps, what you have here is sort of the letter triggers a question, a suspicion. He then has a confrontation with Wanda.
Schnapps is very vulgar, but it's immediate, correct?
Well, the Commonwealth argued in schnapps that Schnapps was not entitled to the instruction because he had prior suspicions. He had prior suspicions in the days before, and his theory on appeal was that...
I'll spare the audience the vulgar part of shops, but it's immediate and it's a vulgar expression of infidelity, correct?
That's correct, but the question is, that was a confirmation of questions.
On hearing these words, Schnapps claims that he went blank and he went berserk. That's Schnapps.
That's right, and that's exactly what Mr. Delarosa said.
Well, no, actually, he said that she snapped. That's what ignited in his statement to police, which is the relevant piece of evidence. He said she snapped. And so what is the evidence that there was any form of revelation?
So it does need to be based on inference. So here's the parallel, and I'll go back to the facts of Schnapps in a second. But the parallel is, in Schnapps, wife said something in the final confrontation that leads Schnapps to understand that, in fact, she has been unfaithful. So in Mr. Delarosa's case, without his testimony, it's not as explicit, admittedly. But what we do have is that his response is, why did you have to lie to me? And all inferences have to be taken in his favor. So between that, the presence of the
So
letter
sorry, can you just
there-
spell it out more?
Sure.
What does that mean?
So what it means is that he told police he couldn't remember her exact words, what she was saying. But we know she was saying things. The neighbor heard things come out of her mouth. Their son described something sort of escalating. Something was said. Mr. Delarosa didn't remember exactly, but we can infer, the jury could have reasonably inferred, that the impression left upon him by whatever it was that she said was that she had lied to him about their child's paternity. Why did you lie? This is a fight about
how does that
paternity.
relate, though, to a revelation at that point? Because that was the revelation of the letter. The letter clearly contained a revelation, but the problem is that for your argument here is that revelation was hours earlier. And
So now I'm going to go back to Schnapps and point to the Commonwealth, this paragraph, which is at 181, toward the end of 181. The Commonwealth quarrels with the defendant's claim that this was a sudden revelation, asserting that the defendant knew of his wife's infidelity for some months. So parallel to our case, he knew of it for some unspecified period of time since finding the letter. And hence, the killing did not follow immediately upon the provocation. That's the Commonwealth's position, contrary to what the court found. The court says the flaw in the Commonwealth's argument is that conflicting testimony and inferences from the evidence are to be resolved by the trier of fact. And what the conflict is, that Schnapps's position was that what he had suspicions, but it wasn't until she confirmed his suspicions that that he lost control.
so what's your best argument that there was, quote unquote, confirmation here?
It was what I was just describing about the evidence from which it could be inferred that whatever Wanda said caused Mr. Delarosa to believe that she had lied about their son's paternity.
Doesn't that support the judge's thought process? I don't know what she said. That affidavit doesn't say what she said. So, and there's this time delay because he's calm enough to have a conversation and goes to sleep. You know, he's not so riled up. And we don't know what she said that when she says she snapped. So doesn't that logically follow that the judge is doing the right thing here?
Well, again, our position is that with taking the evidence in the light most favorable to Mr. Delarosa, as we must, and including the inferences, the fact that he is saying, "Why did you lie?" can reasonably interpreted as he now has the impression in this argument about paternity that she has
Done the
lied.
paternity test, though. He knows he's taken a paternity test and satisfied it. He's in the best position to know whether, you know, she's wondering whether he's made up the paternity test, but he knows the answer to the paternity test because he took it himself, right?
Well, none of that changed after Mr. Delarosa's testimony. So the trial judge thought, and we submit wrongly, erroneously, that this argument, what Mr. Delarosa's description on the stand of more of the detail of the argument was the first indication that Ms. Rosa herself had doubts about the reliability of the DNA test and paternity regardless. But in fact, that was clear from the letter. It was clear from the letter that doubts as to paternity lingered notwithstanding that DNA test. So,
But that doesn't really help you because then the timing is off.
well, so, the Andrade case is a case where the only evidence of the provocation was that the defendant had seen his wife in the company of another man. It doesn't say that they were in flagrante delicto, for example. It's not clear what he saw them doing, but they were together. This was a confirmation of prior suspicions of infidelity that he had. 7 hours went by between that and the provocation, and this court approved of the voluntary manslaughter that was given in that
How about
case.
Cajon? Because I recognize that Underrod supports your position, but Cajon sort of rejects your position.
The difference between, so that was not an infidelity case.
Right, but it's a provocation.
And the difference, the difference really, this case is really unique. It really stands alone in the following regard. In Cajon or cases of that ilk, what you have is provocation. A bunch of time goes by where the defendant does all sorts of seemingly calm things, or perhaps even seemingly planning a murder, and then sort of sucker punches the victim out of nowhere. Nothing else happens after the provocation and the killing. But here you have this incredibly inflammatory letter, which really is quite intimate. It's humiliating, degrading. I mean, this would cause, I think, anybody's emotions to ignite at this point. Some unspecified period of time goes by.
The problem is that some period of time goes by.
Well, but then there's a confrontation about it. We know that the argument was about it. And that's what's unique about this case.
Can I ask you a question? So, listening to your argument uncharitably, you could say that what you're essentially proposing is that if someone gains evidence of infidelity, and then a whole bunch of time later, be it 7 hours, however many hours, they get into a fight with their spouse about infidelity, then they have a claim, which is really incompatible with the whole nature of heat of passion, right? There has to be a sudden revelation that is core. And so why is your case not that case?
Well,
Why are you not proposing that rule?
so that is what Schnapps and Andrade permit. That is the scenario in Schnapps and Andrade. It's particularly Schnapps because
Schnapps is the word berserk is used in Schnapps. Right? He says the vulgar thing, and he says, I snap and I get my gun and kill her. That's not what you're describing to us right now.
well, Mr. Delarosa has this. So in Schnapps, again, it's a confrontation between husband and wife. Yes, what's different with Schnapps is that we know precisely what the wife said that caused him to snap. But in our case, we know she said something. We know we have a fair inference of what his impression of what that meant, what she said. He couldn't remember the precise words, but he formed the conclusion that she had lied to him about paternity. Is our position. And then he lost control. He blacked out. He didn't know what was happening. He was overwhelmed by anger. So he didn't use the word berserk, but certainly his statement to police describes a loss of control. So this is not new. We're not asking for
Can I
a new.
switch you for a little bit? Say
Yes.
we assume you're right for a second, because I went and tracked all the cases that you were citing for the idea, okay, you didn't get a provocation instruction that you were entitled to, and that compelled you to testify. None of the cases you cite on 45 are like that. And it seems like there's a line of cases that say, even you always cannot testify. You have the right to, unless the Commonwealth literally forces you on the stand. They didn't force you on the stand, but I couldn't find any case like what you're arguing where the failure to give this kind of instruction, which results in testimony, results in a constitutional violation compelling you to testify. They're none in your brief, and the closest cases seem to support the opposite, which is you have to be literally forced on the stand or forced to give evidence against yourself.
Well, I have to concede that there's not a case directly on all fours with ours. I think
There's
the
not
two.
even one close. I mean,
I think there are two. I would submit that there are two close. One is the Beauchamp case, which is certainly cited in the reply, if not in the.
which case, sorry?
It's Beauchamp. It's I'm happy to get you the. I know that
It's not in your, that was in your brief, because it's not in your brief when, in the relevant part.
It's certainly in the reply brief.
Okay.
And in Beauchamp, the court rejected the argument, but on opposite facts. So in that case, the law as to self-defense had changed after trial. And so the appellant claimed that if the law had been at the time of trial what it then became, defendant would not have testified. Therefore, he was wrongly induced to
Is this
testify.
the Illinois case?
I'm sorry?
Is this the Illinois case, Beauchamp?
No, this is Massachusetts
Okay, it's
case.
a Mass case,
It's a
okay.
Mass case. If the law had then been, the defendant wouldn't have testified. Therefore, it was the wrongly construed law of self-defense that was in place at the time of his trial that wrongly induced him to testify. Therefore, his testimony should not have come in at the retrial. And there was an objection at the retrial to admission of his prior recorded testimony on that basis, saying he wouldn't have testified if the law had then been what it is now. The problem in that case, or the stated reason why it was rejected, was that there was no indication on the record that that was the reason that the defendant had chosen to testify, which it's quite clear on this record that the only reason that the defendant testified reluctantly was because the voluntary manslaughter wasn't given. So I would encourage the court to look at that case. And then I'll also point out that in the Steves case, again, not exactly on all fours, but informative. In the Steves case, there was a claim that an evidentiary ruling induced the defendant to testify. So they were saying this is, if this bad evidence hadn't been introduced, he wouldn't have testified. Therefore, his testimony was coerced, in the legal sense. And that is the thread that is carried on through all the extra-jurisdictional
I'm
cases.
scrambling to catch up to you. Beauchamp is a case, is the testimony, not that he gets on the stand, but that they admit some prior statement? Is that what a Beauchamp is about? Because that seems totally different.
Beauchamp was, it was, as I said, and I apologize that I don't have the site. But and it was there was a footnote, and I believe it's footnote 12 in Beauchamp, that discusses, there's no support in the, he makes this argument, there's no support in the record for the notion that the only reason that he testified was because of that, the way that the instruction as to self-defense had to be given at the time.
But again, they're introducing a confession. They're not, or a prior statement.
That was a separate issue. With the court's permission, I'll be happy to submit a letter with this and directly point, but again, it is in the reply brief. If that answers your question, I'll just, well, I think that we've covered the key points, and if there are no further questions, I'll rest on my brief.
Okay, thank you.
Thank you.
Attorney Moriarty.
Good morning. May it please the court, Marina Moriarty with Kate McDougall on behalf of the Commonwealth. Your Honors, as an initial matter, I would like to acknowledge a mistake in my brief. The parenthetical regarding Andrade on page 26 of my brief is incorrect. The 1996 case that defense counsel just referenced, I agree with defense counsel's interpretation of the holding of Andrade. I would just point out that the court noted that although the voluntary manslaughter instruction was given at trial, it noted in general that the voluntary manslaughter defense was exceptionally weak because the defendant spent 7 hours in a period of quote unquote brooding and reflection.
If you know, was the propriety of giving that instruction even squarely at issue in Andrade?
I would not say it was squarely at issue, Your Honor. The Commonwealth did not object to the instruction being provided, and the court was assessing the prejudice of improperly admitted hearsay with respect to.
Which was only admitted because it was viewed as a voluntary manslaughter case.
Correct. So it was not squarely addressed, I think is the proper answer. And nevertheless, Andrade does not compel this court to reach the decision that Judge Tibby improperly declined to provide a voluntary manslaughter instruction at the close of the Commonwealth case for 3 reasons. First, the nature of the relationship between the defendant and Ms. Rosa. Second, the ambiguity surrounding the relationship, surrounding the parentage of Ethan. And third, the defendant certainly had sufficient time to cool off after reading a supposedly provoking letter. With respect to the relationship, it is undisputed that this was an on-again, off-again relationship marred by domestic violence. In fact, the defendant had just got out of prison after serving 4 years for abusing Ms. Rosa.
I think it probably makes sense to move on to the other reasons, unless you have a response to how this case is not quite different from, as the defense counsel pointed out in the reply brief from Frat Antonio. In Frat Antonio, the salience of the tempestuous prior relationship was not relevant generally. It was relevant because the supposed revelation that had occurred was that the wife didn't love him, and the sort of sudden revelation was somewhat not that sudden because they had been I don't. Is there a similar argument here that the revelation itself is undermined by the nature of the relationship? I didn't see that in your brief.
I think the point is, I agree that they are intertwined, but I think that the case law requires that there be a sudden revelation of present spousal infidelity. And so I think there's multiple prongs that need to be met with respect to that antiquated defense. And I'm just suggesting that this kind of relationship is not the kind of relationship where you would expect.
Even viewing the evidence as we must in the defendant's favor?
Oh, I mean, absolutely. The defendant himself in his own statement said, quote unquote, they were only kind of together. And so again, I recognize that the nature of the relationship goes to whether or not this would be such a sudden revelation. And I can move on because I certainly think that this was not a sudden revelation. And this is a point that I did not make in my brief, but in the defendant's own statement at page 111 of transcript dated 1:30, the defendant says that Ms. Rosa already told him that Ethan wasn't his. I'm going to paraphrase somewhat, but he tells the police, yeah, Ms. Rosa and her mother, they called me and they told me that Ethan wasn't mine and that I should get lost or else they're going to put me in jail forever. In the defendant's own statement, he recognizes that this issue regarding his paternity has been a thread throughout Ethan's entire 4-year life. And so how can he then say, whether it's the letter or whether it's whatever, then we'd have to speculate, whatever Ms. Rosa said during that fight, how could that possibly be a sudden provocation that's so particular and immediate and intense that it would excuse his conduct?
Although we have here both infidelity and the boy's father, right? We have a combination, and they're brought together in this letter, right?
Well, I think it doesn't matter, Your Honor. In this circumstances, if there was question about Ethan's paternity, if Ms. Rosa had already told him, if he'd had to take a DNA test, I think that questions about infidelity were a thread in their relationship.
I think you got a much better argument because he doesn't just get this letter and go on a rampage. He has a pleasant conversation. He goes to sleep. So I think that's much stronger. But the fact that the letter can set him off, I don't know. It's hard to argue that this letter doesn't set him off.
The letter demonstrates nothing new, nothing that he didn't already know, nothing that there,
What was the record on his knowledge of the victim's relationship with the author of the letter and her revelations to the author about the defendant and his inability to have children?
I don't think there's anything with respect to the defendant's ability to have children in.
So is
the
that a
Commonwealth's case
new
in chief.
revelation? I'm just, the nature of her disclosure of what could be considered private information between the two of them to a third party who may or may not be the father of the child.
I just don't see how in the context of this relationship, this tumultuous, abusive, back and forth, on again, off again relationship, where he was in prison for 4 years.
So if he had attacked her right after reading the letter,
The Commonwealth would concede that if he had attacked Ms. Rosa as she walked through the door after he read the letter, then I don't think we would have objected to a.
okay, so let's move on to the delay.
Sure. So to answer Justice Gaziano's question, I think that in the light most favorable to the Commonwealth, the evidence.
Defendant.
I'm sorry, the defendant, yes. In the light most favorable to the defendant, he states that the fight happened sometime after midnight and before 4 a.m. The evidence is that Ms. Rosa came home, and by the defendant's own words, own statement, they had a conversation. He chose not to bring it up at that point. He deliberately chose. He was not so inflamed that he couldn't keep his mouth shut to avoid a fight, because he knew he needed to avoid a fight because there was an abuse prevention order.
This is home at 9 o'clock, right?
Approximately 9 o'clock, I think in the light most favorable to the defendant. She's home by 9. They are asleep. If something is bothering you in a human nature kind of situation, you cannot fall asleep. If something is so immediate and so particularly intense and personal, he wouldn't have been able to fall asleep.
So I think the argument that the defendant is raising is that whatever it was that the victim said upon her return to bed at 2 a.m. or whenever it was, triggered him. Can you just respond to that?
The law does not allow a reigniting of a previous sudden
What about the
sudden
cases
provocation.
cited by?
I don't. It makes it not sudden. It flies.
How is this different than the cases cited by counsel? I think it was Shops.
In that case, there was a dispute between whether or not the defendant knew about the infidelity. There was a dispute in the evidence. Here, there is no dispute that A, the defendant was on notice that there was issues surrounding Ethan's paternity, and B, he was in jail for 4 years, and there's no dispute that he went to sleep. And there's also, I think you have to speculate as to what exactly she said, because the defendant said he didn't remember. If it was that provoking, don't you think he would have remembered her particular words? He just said she snapped. Again, this is not heat of passion. This is anger. This is domestic violence. This is a murder. He's angry. He tells Trooper Murphy that this was not an uncontrollable impulse. He said that after talking about what he had lost, because Ms. Rosa had sent him to jail, in his mind, she didn't do anything in his mind, she lied because she didn't tell the police that he didn't in fact kidnap her. He talks about what he lost. He talked about he lost $130,000. She wronged him. And he said, and it's all that old just grew instantly. He grew angry in that moment because of the 4 years he spent in jail, not because of what was in the letter. So again, I think
Even in the light most favorable.
even in the light most favorable to the defendant, he needed to say what she said if we're going to be talking about whether what she said was sufficient provocation. And he did not. He had an opportunity. When the police talked to him, he said, I don't remember. And then when he testified, he was more particular. And so even though the Commonwealth maintained its objection for the 3 reasons outlined here today, Judge Tibby gave the instruction. And I would note that even if this case were retried today under Ronke, the misogynistic, old-fashioned defense of sudden revelation of marital infidelity or paternity would no longer be available to him.
Can you address Beauchamp and the cases? Say we don't buy your first argument, but I saw your cases. You cite, I can't remember, Williams and some others, but how about Beauchamp? What's your response to Beauchamp?
I just don't think it's analogous, because in that case really talks about whether the defendant's testimony should come in, whether the defendant's prior trial testimony should come in at a subsequent trial. And I don't think that's the footing that we're on here today. The defendant,
Although there is some discussion about whether he was forced to testify in the first trial.
sure, and I think we would have a discussion with the court, and the Commonwealth would potentially concede that we could not present at a retrial.
I'm just trying to understand how we measure prejudice. If the judge was wrong about the decision not to give the instruction, and that led to the defendant testifying, I'm not sure that meets I'm not sure that's a Fifth Amendment violation, because again, he controlled the decision to testify.
It's not. I don't think it's a Fifth Amendment violation. I don't. I think the case law is pretty clear on that point.
Well, the case law, I don't think there's ever been a case just like this.
We've had similar cases as far as a required finding goes, right? There's Supreme Court cases on this where the defendant is entitled to have the judge make a finding on required finding. You can't just delay it, defer it to the end of the trial, because as I think it was Scalia pointed out, the defendant needs to know at that point whether to put on a defense. So that ruling by a judge is critical, and we protect the right of a defendant to know whether or not to put on a defense. So if the judge is wrong, there is prejudice, correct?
I don't know if the judge is wrong, if there is prejudice. Because I don't think there's a case directly on point. I would, and I agree that the defendant's case did not get stronger after he testified. I think that's a fair assessment of the trial evidence.
I don't see you having, I don't find his testimony itself prejudicial, because the differences are marginal. But the issue is whether being forced to testify to keep the instruction is prejudicial. And it just seems like that's a novel issue.
And I don't think this court needs to reach it, frankly.
It hasn't been raised in a self-defense context either?
Not to my knowledge, Your Honor. And again, I don't think this court needs to reach that argument. I don't think this court needs to consider.
We don't need to reach it as long as you are right on the first issue, but we do need to reach it if you're not.
Correct. Yeah. Yes. And if there are no further questions, I'm happy to rest on my brief.